Wanted to welcome everyone back today. This is week five of the Manage Your Practice webinar series. And there's only one more session after today. We really hope these sessions have been helpful and motivational as you seek to level up your business. We're all trying to do better, right? And what better way to do better is to enlist the help of other experts to help us do what it is that we want to do with our businesses, work with more of our ideal clients, figure out the business of doing financial planning better. So we want to welcome to those who are joining us for the first time, and welcome back if you've been with us for the past few weeks. I am your host, Cameo Roberson, founder of Atlas Park Consulting. We are a business management consulting platform for financial advisors and other service-based entrepreneurs, where we really teach our clients how to build habits, right? Instead of just learning techniques. How many of us have had situations where you learn all of these different techniques, but you never implement them? You think about the financial plans that you create for your clients. If you don't help them with implementation, how far are they going to get on their financial goals? And so at Atlas Park, our coaching and virtual COO solutions help our clients clarify their business vision, move ideas from concept to profit, organize operations, escape burnout, and save time. So if you were with us last week, Christy Royce of KLR Consulting gave an engaging talk about effective leadership and what's required of leaders to move their teams forward. How to work with different personality types based on the 4 basic DISC styles, learning tips to people read. Now, this one was really good for me because as I thought about talking with more prospective clients and figuring out what are some of the best things I should say to compel them to be interested in working with me, knowing about those 4 basic DISC styles and how to people read, right? And having more effective conversations was something that really stood out to me. And so I have a list now of those 4 personality styles, and I keep it next to my desk. So as I'm having conversations with prospective clients and they're displaying some of those personality traits, I can then adjust my communication style with them to hopefully be more effective and close more business. So last week I emailed Christy's slide deck, and I encourage you to reach out to her with more questions. And if you're interested in having your own DISC assessment performed, I mean, how much more effective could we be if we each knew our own individual DISC styles? Would you agree? Wonderful. So as in usual fashion, at the end of today's session, we're going to have some giveaways, one being one of our sponsors, Nudge, which is a tool that helps financial planners assign tasks for their clients and have shared to-do lists to manage those tasks. A few minutes ago, I just talked about implementation. If you can't get your clients to do what you need them to do, how effective are you going to be as a business owner, as a financial planner? And so there are all these tools out there to help us figure out how we can do our business better and help our clients do what it is we need them to do. So a couple of housekeeping items as we get started. As you know, to save any background noise, please mute your line if you're not speaking. Add your questions to the chat box at any time and we'll moderate them, or feel free to unmute yourself and ask your question live if you prefer. Winners of our giveaways will be announced at the end, and we really appreciate your time and thank you for being here. I'm going to share my screen with you. Let me know when you can see it. By simple yes works fine. So many of you may or may not know, but I spent over 15 years working for fee-only and fee-based wealth advisory firms. And during that time, I spent a lot of time in compliance, right? And I will tell you, to financial advisors, the word compliance is almost like a bad word, really. It's the legal aspects that govern these entities and causes a lot of frustration. Why? because it's a ton of legalese, rules, regulations, and really dictates how advisors manage their firms, which runs over into the operations of an advisory practice. And that's where my work comes in. In particular, I can remember at one firm how it was always a big deal to make sure we had the investment management agreement ready for each prospective client meeting, and to make sure we had the right one, right? There's different agreements for different types of clients. We were working with individuals as well as institutional clients, and each one had a specific provision within the document. And so we had to make sure you had the right agreement. And in the excitement of onboarding a new client, you can often forget about gathering all of the required documents, especially if you're not using workflows to remind you of the documents that you'll need or a checklist. And so as we get started today, and as you think about yourself as a business owner, requires each of us to do our own due diligence, right? Making sure you have the right protections and insurance in place to protect your business investment, things like E&O insurance, and having a solid investment management agreement. And over my time at these firms, I came across a number of problems in relation to the investment management agreement. In particular, problem number one, trying to cut costs by borrowing another advisor's investment management agreement and tweaking it. So I'm going to tell you, I'm a part of several advisor Facebook groups. And this is one request I see a lot of times. Advisors at various stages of growth, usually smaller shops, that will add a request to the chat about wanting to see another firm's investment management agreement in the hopes of using it within their own practice. Now, I'm sure you can see red flags all over this one. The problem is how one firm's investment management agreement was drafted may not meet the needs of the advisor who borrowed it, and it may not be state specific. Advisors who are SEC registered go to the SEC directly. Individuals who are less than 100 million in AUM go to individual states. And so if you think about borrowing an agreement, you're in California, you borrowed an agreement from an advisor in New York, how could that potentially create a lot of issues for you? So the next problem that we have is wishful thinking that nothing will ever go wrong, that honeymoon phase, right? The beginning of a client relationship, we're excited and we want to believe that our clients will always be happy with us. But the reality is the best of intentions don't always yield the results that we want, the results that we're looking for. And we really want to make sure that we're protected and having the right legal documents in place. And when I'm working with my startup RIA clients, there's actually a checklist that I use to help clients work with the right legal and insurance professionals to get the right protections in place. Problem number three, a mismatch between an advisor's practices and the ADV disclosure document. Now that ADV is a document that regulates the business practices of that investment advisor. And I'll share a quick story with you. I worked at a firm, and this firm was subject to SEC oversight, which, as I mentioned, they had over 100 million in assets under management. And we were subject to an audit, and each member of the service team was interviewed by the auditor about the onboarding process for each new client. They randomly selected a variety of clients who were onboarded at different times. And there was a lot of focus on the steps the service team took in making sure the right legal disclosures were provided to each client. We passed that exam, but it was a reminder that our practices and what was disclosed in that ADV document needed to be in alignment. So as we take the time to set ourselves up for success, these are all areas I've seen in my work with RIAs and topics of discussion for my consulting clients. And if there are any concerns or questions in this particular area, working with an expert can help you have a very strong first line of defense. And we all live in this day and age where things can go wrong and very fast. So I share all of this to set the stage for today's presenter, Ben Douglas of Ryman Law. Ben provides legal counsel in all areas of asset management, including private investment advisors and wealth managers. He handles legal matters ranging from fund formation, regulatory compliance, and service provider relationships to complex sales and acquisitions of asset management businesses. Today, he's going to share on the risks of a poorly drafted investment management agreement, share some war stories, and what advisors can do to protect themselves. The last thing you want as a firm owner is to leave yourself open to significant vulnerabilities in this area. We've spent a lot of time building our businesses. It makes no sense to leave this door of potential vulnerabilities open. So with that, I'm going to turn it over to Ben.
Great. Thanks, Camille. Honored to be the penultimate presenter in this series. And I say that not just to show off the use of the word penultimate, one of my favorite words, but also to remind you that Camille will be the ultimate presenter next week. So just to, Camille really set the table well in talking about how much the investment management agreement is one of those items in your business that you won't think about until you have to think about it, at which point there's probably something bad going on that you regret. So on the next slide, I just wanted to underscore what Camille had touched on before, which is, again, if everything's going well in the advisory relationship, the agreement that you have with the client is just going to gather dust in the file, and that's fine. They're never going to look at it, and more significantly, their lawyer will never look at it because they'll never hire a lawyer. If the account experiences losses that the client thinks somehow were the fault of the advisor, then that investment management agreement could very well end up as being a major source of liability, or if it's done correctly, something that protects you from liability. So let's go to some specific risks on the next slide. So the sort of more business risk is that if an investment management agreement isn't drafted clearly, even before you get to a legal risk, clients may not have a clear understanding of what your duties are, what their responsibilities are, what you're committing to, what you're not committing to, and laying that out really clearly for clients is important, because it means that you're setting their expectations, along with other ways. Obviously, they're in conversation, but having clear expectations set out in writing, especially delineating responsibilities and delineating how you're going to manage the account, is a key way to avoid misunderstandings that lead to a deterioration of the relationship. As I mentioned before, when the agreement has holes in it, either in terms of what your obligations are or the legal standards you set for yourself, and I'll touch on that later, you greatly increase your risk of private litigation. And private litigation can sometimes be the very worst consequence, because what that means, put bluntly, is that you could have to make good on all of your clients' losses in an account if things go really badly and there was a problem with the agreement or a problem with the way you complied with the requirements of the agreement. And I'm going to touch on some more of that later, but that's, kind of in a worst case scenario, a client could lose a bunch of money and you're going to have to make good on it. And then regulatory scrutiny. The SEC and various state regulators always look at the agreements that advisors have with clients when they do examinations, guaranteed. And they will be looking for problems with that agreement, provisions that should be there that aren't, provisions that shouldn't be there that are. And they'll look at each effective promise that you're making to the client in that agreement, each representation as to how you're going to run their account, and they're going to compare it. This is something Camille mentioned before. They're going to compare it to two other things. They're going to compare it to the disclosure in your Form ADV. Does it match up exactly? And they're going to compare it to what you're actually doing. So I'm going to come back to that theme as we go through this. There's a vulnerability. Whenever there's any daylight between what is in the investment management agreement and your public disclosure in your Form ADV and or your actual practices in the firm, you're going to have a problem that regulators will find. They will be actively looking for those kind of discrepancies. So the next slide deals with an issue that, again, is so basic and boring, you're not going to think about it as long as it's done right. Custody. Who has the assets? Who's holding the assets? And custody doesn't just mean who literally has the assets in their account, the client's assets. It means who has the power to control where they go. Now, if a proper custody arrangement for almost all advisors is going to involve the assets being placed in a large institution, typically a broker-dealer, Schwab, Ameritrade, Fidelity, someone like that, and the client giving you a power of attorney in the agreement to trade the assets, but very clearly excluding you from having the authority to move the assets out of the account, other than to another account also in the name of that client. And it doesn't matter whether or not you ever actually move assets somewhere other than a client account. If you simply have the authority to do that, and that can often happen inadvertently if the agreement isn't drafted properly, the SEC or state regulators could say, hey, you effectively have custody of these assets because you can control them. And that will lead to a bunch of consequences that you do not want. There are requirements of an advisor is deemed to have custody, one of which is they have to have a surprise audit at least once a year. And almost nobody wants to go down that road. It's a big hassle. So the typical way advisors handle this is to avoid having custody. And that means making sure that the agreement is drafted in a way that makes clear where the custody is and that the advisor doesn't have it. So again, this is a situation where your Form ADV will discuss your custody policies and procedures. They have to match up with your actual practices, and they have to match up with the agreement. Something that's related to custody is making clear to the client what kind of account statements they're going to receive and from whom. In some cases, a client may only get an account statement from the custodian, and that's okay. But if you are sending out an account statement too, you've got to be very clear with the client, and this would be in the agreement, that they should always compare that statement, the one that you generate, to the one they get from their custodian. And the underlying reason for this is so that the client is told, hey, you should make sure that the advisor is not giving you false information about how your account is doing. Because in the sort of nightmare scenario, you have something like with Bernie Madoff, where he was sending out completely falsified account statements because he was also effectively controlling the custody, so that the clients were never, because the investors were never getting the true information. So the idea is that clients always have a right to get that information directly from the custodian. And if you generate your own statements, you need to also tell the clients that they should need to compare them just to check your work. So the next issue is the investment guidelines and the restrictions. Both of these are important. It seems often an obvious point that when you have a client says, I want you to invest my money this way, and there could be absolutely no restrictions whatsoever. And if the account says the advisor has complete discretion to invest the money in any way that the advisor sees fit, any level of concentration, like no diversification requirement, international, domestic, equities, bonds, it's all good. That gives you a lot of leeway in it, and that greatly reduces your legal risk. But the reality is clients are going to want some kind of guidelines and restrictions in their account almost always. And once you put those in, you need to make sure that you're adhering to them. That's vital, so that when part of the process that Kenya was talking about, when you're doing the intake, whatever guidelines are attached to the agreement, you need to make sure that those match up exactly with the guidelines that you implement on your trading desk for that account, so that there's never going to be a deviation in the client's account that deviates from what's in the investment management agreement. Now, as the relationship continues, there are going to be times when maybe that changes. Maybe the client wants to take a different approach than was originally planned, and that's fine. But this is, again, an area of significant risk is when it's not done right. You got to make sure that there's client consent for any deviations. And I can tell you, I had sort of as a war story, a client had a perfectly, drafted set of investment guidelines. Then its client called up and said, "Oh, we want you to basically pull a bunch of money out of the market." They were feeling nervous about what was going on. So they said, okay, so they pulled a bunch of money out of the market. Over time, the client slowly let them put it back in. Fast forward about a year and a half, the client calls up and is complaining, says, "Hey, why has my account fallen so far behind its benchline market performance?" Well, obviously the answer is obvious, because you weren't in the market and the market was going up. But problem is the client's memory was a little fuzzy. They didn't remember it that way. And it turned out my client had not documented it in the proper way. They made some internal notations of discussions they'd had with their client, but that's a problem, because what happened was the client insisted that they'd been wrong. They were demanding that the advisor make up those losses. They complained to the SEC, which did a preliminary investigation of what had happened. In the end, it turned out okay. The client sort of ended up sort of grumbling and going away. But the big lesson here is, when you have a written agreement, any changes to it, and this is a particular area when there are changes to investment guidelines or restrictions, they need to be in writing. Simply having a client call up and you saying okay and implementing it, you can't rely on that. That's because memories are going to change depending on the ultimate, the way things ultimately turn out. So I always tell my clients it's sort of a hierarchy of communication and when you're sort of documenting things. The highest, at the very top, is a written communication from a client that specifically requests that you do something. From client to advisor, and an email is fine. Please change please remove half of my money from the market and put it into a cash account. Great, you've got it, they've requested it. Then, below that on the hierarchy would be a follow-up on a conversation, which you send an email to the client that says, as we discussed, we're removing half of your assets from the market and we're going to put them into a cash account until further notice. Please respond to acknowledge this. And you actually get a response from the client in which the client says, yes, that is correct. So even though they didn't originate the communication, they're still taking ownership of it, they're agreeing with it. Next best below that would be you write an email, they don't respond, you write again and say, hey, just unless we hear otherwise, we're going to assume that this is correct. Although frankly, if someone's ignoring that, you should probably follow up with a phone call and elicit some kind of written response from them, at least acknowledging that they received the communication. Mm-hmm. Again, this would defend you against a later complaint, whether from private litigation or from a regulator, that you did not properly have their authorization to change the account instructions. And kind of at the bottom of the hierarchy is just having a phone conversation and just sort of making a note to yourself. You make a contemporaneous note to yourself. It's better than nothing, but it's not a lot better than nothing. So really, if something started off in writing, it needs to be, the only way to effectively change it is to do that in writing as well.
Yeah, Ben, can I add a quick comment? I think
that's please.
Great segue into the importance of leveraging your CRM to document things like this and having trading procedures and processes in place to protect yourself. I can remember many times clients would call me wanting to buy different securities in their account, and I would follow the process that Ben laid out. I documented in an email, confirm it with the client. These are the number of shares that you want to purchase of this particular security, and then have the client respond back to that email affirmatively. So I took the request via phone, but then I had it documented to make sure that things were covered. Because if that particular security, at the time that I placed the trade, declined in value, the client could come back and say, I never wanted you to do that. So you always want to make sure that you cover yourself, and having a process in place can help you safeguard yourself.
So the next area that always is covered by the investment management agreement is fees. That's a key part of any business relationship, is how you get paid for it. And that has to be very carefully documented in an investment management agreement. Now, the most sort of basic way of charging fees would just be a percentage of the assets under management. And if all of the assets, again, are custodied at a third-party custodian and they're all in publicly traded equities, you simply say, we're going to take a certain percentage of the account value. We're going to charge it at a particular point in the during the cycle, typically quarterly, at the beginning of the quarter, the end of the quarter. There are different formulas. It could be a snapshot of the value on the calculation date. It could be based on a weighted average of the account value over the period, so that you would look at the weighted average over a quarter and then charge on the last day of the quarter. There are many different ways to do it, and there's no way that's inherently right or wrong. However, again, this going back, everything has to match up. The way you say you're going to charge the fees, not just the percentage, but the timing, the way the date on which you calculate the fees, the formula you use, whether it's a snapshot or a weighted average over a period, it's got to match up exactly what's in your Form ADV and the way your internal accounting systems are calculating and causing the fee to be charged. It's vital. This is for sure something that SEC and state examiners will zero in on. And if they see any daylight, they're going to say, okay, there's a little difference here. Now, if it turns out you're actually undercharging, you'll probably still get a write-up, like a fix-it ticket, what's called a deficiency letter from the examiner. However, but then you've learned your lesson. But if it turns out you're overcharging, that could really be an issue. At a minimum, they're going to make you disgorge any overcharge with interest. But if it has gone on for a long time, if they feel it's particularly egregious, potentially they could charge you with fraudulent activity and bring a lawsuit. That's sort of a worst case scenario with a regulator. So you really want to be sure that everything is matching up, not overcharging or undercharging, and that everything is exactly the same, what the language in the agreement, the language in your ADV, and what you're actually doing. And if anyone is charging a performance-based fee, meaning a fee that varies depending on the profitability of the investments, then you've got additional disclosures and representations you need from clients. I won't get into that here, but there are additional requirements there that need to be addressed in the investment management agreement and elsewhere in your business. Next is a liability limitation. This is a topic really only a lawyer can love, and I won't spend too much time on it. But I'm sure whenever you look at contracts, they always talk about is the standard of liability, negligence, gross negligence, and lawyers can spend lots of time arguing about that. Again, this is not a particularly interesting topic to non-lawyers, and it's what it is. It doesn't matter until it does. But the key thing here is make sure that the standard of liability is the lowest permissible. Now, you still, as a fiduciary, you have a pretty high standard of liability. You just want to make sure that it simply says that you're not liable for merely making a mistake, up to the point where you're not breaching your fiduciary duty. So, I won't say any more on that, but that's something, there's no reason to leave a hole there that gives a plaintiff's lawyer, if someone's suing you down the road, any more leverage than you need to give them. Proxy voting, again, this is something that you probably don't think much about. Most advisors of my intuition disclaim responsibility for voting proxies. Not always, but you just want to be clear about it. Be clear, either we are not going to vote the proxies for any stocks that we own in your account. In that case, you would probably also want to make sure that all the notices are forwarded from the custodian. Say if someone has an account at Schwab that you have trading authority on, instruct Schwab to send all proxy notices directly to your client so that they don't even cross your desk. And be clear in the agreement and in the Form ADV that you do not vote proxies. Now, on the other hand, if you do vote the proxies for the stocks held in your client's accounts, you need to have very clear policies in place as to how you will vote them. What most people do is they will follow their various services that have a whole list of sort of principles that they use to decide how to vote different shareholder matters, and they sort of go through that and they give a recommendation, and it's fine. You say we're going to follow those and just vote according to those recommendations. You just need to be really clear in the investment management agreement and in the Form ADV that that's how you're handling proxies. Valuation is important, particularly because it's going to affect how you charge your fees. If your fee is a percentage of the assets under management, meaning not just a flat fee, but it's going to vary depending on the value of the account, then how you value the account is important. And there's a potential conflict of interest, because if it's overvalued, then you are effectively overcharging the fee. Now, if everything in the account is are publicly traded securities, whether they be mutual funds that have a daily valuation, or publicly traded stocks or bonds that have a market price at the end of every trading day, this is really not important. But if you are holding some securities or other investments that are not valued every day, you need to have a clear procedure as to how you're going to value them. What happens if something is thinly traded and maybe trading is suspended at the before the end of the day, so it's not clear what the value should be. So you just need to be very clear what your process is. Again, there's more than one right way to do it, but you just need to pick a process, state it clearly, and follow it. Again, always don't deviate from what you say you're going to do and what you're actually doing. Again, this is really most important when you've got illiquid or private assets. So if you're only in publicly traded securities, this is really not going to be a big area of risk. So brokerage. Now, this is something that regulators always take a look at, because this is the cash register. This is the biggest expense for your clients' accounts, other than paying your fees. In some cases, it could be more than your fees. They're paying commissions on the trading. If the account is trading a lot, then that's going to be a significant cost. So they're going to be looking at how you choose the brokers. There's this general expectation of best execution, but best execution can mean a lot of different things. It doesn't mean just getting the absolute lowest price per share on a trade. There are a lot of different factors that can come into play. You need to be very clear what those factors are. Advisors are required to lay them all out in their Form ADV. The investment management agreement should at least make reference to those factors. They don't have to list them again. They can make reference to the Form ADV. And you need to be very clear with how you're choosing the brokers, what the standards are, and make sure that the clients understand that. And they can, one way to make it clear they understand it is they're signing off in the form, in the investment management agreement, as well as receiving your Form ADV. And sometimes there could be some conflicts of interest. And the biggest conflict of interest is when you as an advisor are receiving something of value from the brokers who are making your client trades. If all those brokers do is just execute your client's trades, there's not much, the regulators aren't going to take much of a look at that. They'll sort of default, they'll give you a lot of deference as to how you chose them. But is there anything that you're receiving back, whether it could be research or other kinds of sort of support services that help you run your business better, effectively displacing some of your costs? If the brokers are giving you services that otherwise you would have to pay for with what we call hard dollars, meaning your own money, rather than the brokers handling that themselves, then there's a problem. Again, it's not a fatal problem, but it's something you need to disclose. You need to make sure that you've got a practice and some process in place in which you're sort of making sure that you're not being overly influenced by that. The clients are still getting good execution. So again, something to think about. It needs to be addressed in the investment management agreement. You need to disclose what the potential conflicts are. And then the last thing I'll mention in terms of brokerage issues are the block trading. When you trade more than one, put more than one client trade with another, and which often makes sense. There's an economy of scale. You've got to be really clear about how you're going to allocate the sort of different prices when there's some diversity of the pricing. They don't all trade exactly at the same time. And it doesn't have to be that you will always average everything out for every single trade so that every client gets exactly the same result every time. You just need to have some process that is sort of fair over time, and there are different ways to do that. Again, I won't get into the details on that here, but just be aware that something you need to address how you're going to do it, both in your investment management agreement, and then it'll be addressed either directly or by reference in the to the Form ADV as well. So just be aware that that can be a problem. Assignment. So the investment management agreement is a contract, and the normal default rule with any legal agreement, any contract, is that it can be assigned. If I have an agreement to sell a car to Cameo, because normally I could assign that agreement to someone else as long as I have a responsibility to deliver her a car for a fixed price. If I get somebody else to do it, they deliver the same car, then that's all good. She can't refuse to buy the car because I've assigned that contract over. But it's very different in the context of investment management agreements. Under the law, you can't assign the agreement without the client's consent. And it makes sense because it's not just a car. A car is a car. No one cares where you got the car from. Investment management is a very personalized service. It's something that someone is hiring a specific firm, a specific person. So it is fair that the client gets to say, no, you don't get to just pass me off to someone else unless I agree to that. So there has to be a provision in the agreement that says that the agreement can't be handed over to another firm without client consent. Now, the one area where there's some flexibility is using a negative consent provision. And that's something I recommend to my clients, is that when they set up their agreements, especially if they think the firm may have a change in the partnership makeup down the road, or may even sell itself completely, all of those things can potentially be considered an assignment if the control of the firm changes. So we put in provisions that will say that the advisor can inform a client that the agreement is going to be effectively assigned because there's going to be a transaction in the firm. And if the client doesn't object, and you need to give them a good amount of notice, but the client doesn't object, and that will be deemed to be consent. And that could be very helpful if you've got hundreds of clients and the firm is being sold, or there's a change in control, and not have to actually chase all of them down and get them to sign off. Because often there are situations where the clients are fine with what's going on, but it's just hard to actually get somebody to officially affirmatively sign up on something. And I just saw a client, just in the chat, a question popped up. Does assignment apply if the client is handed off to another advisor at the same firm? The answer is, from a lawyer's standpoint, the answer is no, because your contractual relationship is with the firm. It's not with an individual. Obviously, in terms of a client relationship standpoint, you would want that consent, but legally, no. Legally, the relationship is not with that individual advisor. Again, on to sort of the lawyerly issues. We don't want to think about what happens if there's a dispute, but I always recommend to my clients they have provisions that allow for mandatory arbitration of a dispute. You don't want to end up in court. There are various reasons. There's an efficiency to being in a private arbitration, and frankly, it's probably a better place for an investment advisor to be. Juries are generally more likely to sort of be swayed by appealing facts, even if they don't really match up with the law. If they feel bad that somebody lost a bunch of money, they may just think, oh, well, they should get it back, even if they clearly don't have any legal right to it back, even if the advisor did nothing wrong. And that you don't want to expose yourself to that risk if you can avoid it by having it go in front of what's typically a retired judge who's going to have experience with securities law matters and is going to kind of look at it much more dispassionately than a jury would. And finally, and this is just makes things easier, you want to be able to communicate electronically with your clients. And I'm sure the vast majority of advisors, that's how they do business. I mean, that's how all of us do business. We don't handwrite or type up letters and fold them up and put them in an envelope and put a stamp on and put it in the mail. But there's, if you want to make sure that everything is legally binding in terms of the agreements you have with your clients, in terms of the kind of things I talked about before, with when you're giving, making changes to investment guidelines, things like that. You want to make sure that clients have clearly consented when they first, hand sign the agreement, that everything in the future is going to be electronic, that all required notices under the agreement are going to be electronic to their, an email address that they've given you, that any required disclosures are electronic. And for instance, you're required to give them your Form ADV every year when it gets updated. Well, you don't want to have to print it out and stick it in the mail and send it to them. At least you'd like to have the option not do that. So you want it to be clear in the original agreement that they're consenting to either receive it by email, or what some advisors do is they simply send a notice by email with a link that says our new Form ADV is available. Here's a link, to the page on our website where you can find it. Anything like that. Again, in any other communications that are happening, you just want to be clear that they've consented to an electronic communication. So again, so that if there's some problem down the road, you don't want them in a position where they can claim, well, I didn't receive that, and plus they were supposed to send that to me by US mail, so it doesn't, they weren't allowed to just default to email. You want to be able to pull up the original agreement and say, no, you actually agreed to have it by email, and obviously you keep a record of all any electronic communications you send out, so that you have sort of proof that the communication went to them. So that's here's me, and then I will open the floor to any further questions. And while you're pondering those, I'll just say, the investment management agreement, again, it's not a sexy part of your business, but I would say it's either your first line of defense, it's defense exhibit A, or if it's poorly drafted, it's going to be plaintiff's exhibit A. So you really want it to be working for you, and a good guideline for a lot of your business practices, so that the kind of things that Cameo will advise you on in your advisory business are sort of already tracking in the legal document that you have underlying the relationship.
And I've got a quick question for you.
Yeah.
And this may be something that compliance consultants handle, but I'm curious, at what point in the registration process should that IMA be created? And is that something advisors should consult with an attorney with directly, or will a compliance resource consultant be able to handle that for them?
Typically, the compliance firms are, at most they're going to be giving you sort of a form agreement. Again, so you get some of the dangers that you mentioned at the beginning, just sort of taking a form and putting in there. Those forms might have 90% of what you want, or 95%, but that last 5% is going to be where the problems are. It's sort of like having a boat that is 95% not leaky. That's not gonna be very helpful when you're out on the lake. So honestly, I think it's mostly a one-time investment to get a really good agreement in place and really think through, what are your practices? How do you actually do things? And it's a good time, along with when you're both drafting your original Form ADV and when you're doing annual updates, it's a good time to sort of try to wipe your brain clean and think, let me think about how we're actually doing things here, and does this match up? Because once you've got it in place, it's hard to change. It's hard to get a client to sign a new one. I've had some clients where they realized they had some real problems in their agreements, but then they were loath to go back to their advisory clients and ask them to sort of change the agreement, because that's only going to sort of raise flags and create disruption in the client relationship. So it's worth doing it right from the get-go. It doesn't need to be done when you register, but certainly before you're signing up clients, you should have a really tight agreement that really maps what you do and has all of the legal I's dotted.
Great. We got a question from Robert in the chat box. Ben, can you discuss recommendations if you're providing education and financial health to 401k participants and employees are asking for investment advice? And I'll mention that they're not looking for ongoing management, and they may not meet the minimum asset level to become a client.
Yeah, so this is obviously, if the firm's just providing 401k options to the employer, that's sort of a different service. But if you're actually, if an employee says, hey, this is my financial situation, and Robert, tell me if I'm understanding this right. If this is my financial situation, which of the various mutual fund options that you have would be right for me? The answer is probably best not to be sort of giving customized advice to those individuals. Again, realistically, it's pretty low risk if you're doing this in just a conversational way. I wouldn't. It wouldn't worry me too much. You just say, well, if you think investing long term, you should be in these kind of equity funds, something like that. As long as what you're straying into is pretty conservative. But I wouldn't make a habit of it, and certainly wouldn't. The firm shouldn't hold itself out as providing sort of individualized advice unless, again, there are agreements in place that would support providing that kind of advice, as opposed to just the general 401k plan structuring and sort of creation of options for employees as a class, not for a specific employee.
Great question, Robert.
Ben, I have a couple. The first is just around electronic communications, and I was thinking about Cameo earlier, talking about being on the phone with clients and getting trades confirmed by email or whatever. But what about texts? How do texts feature into the whole thing of electronic communication, if at all? Just given that people are texting now.
Yeah, something I've had with my clients. I think one particular likes to text me things. The short answer is, it's much better to have email. You want to have a trail, both because that's what regulators are going to look at when they come in. You're required as an advisor to have retention policies on the emails. Texts are a lot harder to keep. I mean, you could end up sort of screenshotting them and saving them to an archive, all of that. There are different ways to do it. I would say certainly for texts that are where there needs to be a record of the conversation, probably a follow-up email would be the best way to do it to that client. Say, just confirming our text discussion, you want to buy XYZ, or you want to change your allocation, you want to put in this restriction, take off that restriction, whatever it is. And again, kind of that hierarchy of communication. If you don't want to make the client send you the email, that's fine. Just you send the email and ask them to confirm it.
Great.
Ben, you up for another question?
Yep.
So Robert asks, what liability exists if you provide tools such as Riskalyze and eMoney to participants? They use their risk results to come up with their allocation, and they never change it, even if potentially their circumstances change.
So if these are just participants in a 401k plan, I mean, frankly, there's some risk to the employer sponsor there, and that's something that goes to some of their liability as a fiduciary, as the sponsor of a 401k plan. I think simply providing tools is not so much as an investment advisor, but as a 401k sponsor is fine. And it's, again, you don't have the duty to oversee individual participants' use of the 401k plan, partly because you don't know, and it's not your job to know, and you shouldn't take on the responsibility of knowing what their whole financial picture is. I mean, it could be that they've decided that they've got investments all over the place, and they're going to just put their riskiest stuff in this 401k because it makes sense from a tax standpoint. You just don't know that, and you don't. That's why I would mention before, you don't want to sort of get in the business or hold yourself out as providing individualized advice when you don't have a advisory relationship with someone, because it can only sort of be used against you. Oh, I see that if they aggregate with eMoney, theoretically, we would know. Yeah, I mean, you're right. Theoretically, I think what I would recommend in that case is that you have, you'd want to have very clear disclosure when they're using it, that you're not going to be overseeing this, that you don't have an advisory relationship with them, and that they should engage, an advisor or they should consider engaging an advisor to help them guide that decision. You just want to be clear that you're not that advisor and you're not taking that on, notwithstanding whatever information you may theoretically have access to.
That's great. Love these questions. And it just reinforces the need to talk with an expert like Ben, who can help you figure out the nuances of your own firm's investment management agreement. Maybe you're getting ready to go through some changes. Ben talked about if you're going to be adding partners to your firm. There's just a lot of different caveats that can come up, and you want to make sure that you're protected. Before I announce our winners for today, are there any more questions? We're coming up on the top of the hour here. All right. Well, I want to let Brad Wright and Marie Thomason know that you are our winners for today. I think Marie had to jump off the call, but I will send you an email with information on your giveaway for today. So we thank you for participating. Now, as I mentioned when we first got started, oh, Marie, okay, awesome, you're here. When we first got started today, I mentioned this is week 5. Week 5 out of 6. So we're at the tail end of this Manage Your Practice webinar series designed to help you level up in all areas of your practice. So next week, I invite you to come back, join myself and Ariel Figueroa, who will be talking about systems and automation, right? You have all these areas of your practice that you got to manage, you got to work with clients. How do you get to a point where you can do the business of financial planning better? And so I ask that you join us. I'm going to ask Ariel to introduce herself and to share a little bit about what she's going to be talking about. But this is kind of the culmination, bringing it all together. As I mentioned earlier, you make recommendations to your clients. We talked about a bunch of recommendations you can make within your business. How do you take all of this, package it together, put it in a nice package, and then implement it within your firm? And that's what we're going to be talking about. Ariel, you want to add?
Sure. Thanks so much, Cameo. I am so excited for our presentation next week. As Ben said, the ultimate presentation. I work as an advisor at Modern Money Advisor, but I also have a separate business, Sphinx Automation, where I help other advisors and service-based businesses set up their technology and utilize automation to add efficiency in their practices. And Cameo and I often work together because she helps build the systems, and then I work with clients to take those systems and put the icing on the cake, so to speak, to use a very tasty analogy. So once you have those systems in place, maybe you're not really sure how do you utilize your tech in the most efficient way, or maybe you've dabbled with automation, but you're not really sure how it can make your practice better, make you more streamlined, and give a better client experience. Those are all the things that we're going to be covering next week, both Cameo and myself. Just to give one example, Ben mentioned sending a notice electronically about ADV updates. You could take the list of clients, compile that, create the email, add all the recipients to the email, send the list with the link. That's more efficient than sending out the ADV by paper, but why not take it a step further and make that process automatic so that every single year when your ADV updates go out, rather than compiling the list, creating the email, adding the recipients, you know that it's going to go out on a timer without you having to even worry or think about it. It's just one burden that you can eliminate from your to-do list that helps you be more compliant and make sure that you're not encountering any of these regulatory issues, and just gives you more capacity to work on client relationship building, getting more sales, and many other things. With all the hats we wear as business owners, there's so many other things that you probably prefer to spend your time on than handling administration and compliance. So next week, when Cameo and I present, in my portion of the presentation, I'll be talking about advisor and service-based business tech, how to utilize it and maximize it, and then ultimately how to automate it. And we'll have a special guest, a client that we've both worked on together, who will be helping us present a case study for what we did with him, give you guys some examples, get the gears turning, and give you some ideas of how you might add technology, systems, and automation in your own practice.
Fantastic. Thank you, Ariel, for sharing. So we got an exciting lineup, a last session, and we hope that you will join us, let other financial advisors, other service-based entrepreneurs know, because I know this is a big area that a lot of advisors want. Everybody wants automation. But in order to get to the automation piece, you got to have good process and good systems. And so Ariel and I will be talking about how merging those two worlds can really create the efficient practice that you desire. So I thank you for joining us today, and we will see everyone next week. Have a great rest of your week.